Hello, and thank you for joining us today for Are You Prepared? How to Respond to Industrial Plant Accidents Given Stepped-Up Federal Enforcement webinar. I'm Heather May, the Technical Administrator for this webinar. Before we begin, let me first note that this event is in listen-only mode and is being recorded. Please feel free to message any questions you may have throughout the program by selecting the chat icon in the ReadyTalk toolbar. Time permitting, we will answer all of your questions at the completion of today's presentation. If we do not get to your question, someone will follow up with you by email. We will also be applying for CLE credits for this program. Please be on the lookout for a follow-up email with a link to the attorney affirmation form. Please complete and return to me at hmay@hunton.com, and we will seek CLE credits on your behalf. Let me first introduce you to our moderator for today's program, Chuck Knaus. Chuck has been working on EPA's risk management program addressing accidental releases of chemicals in industrial plants since the origins of the program. From 1987 to 1990, Chuck served as minority counsel to the U.S. House of Representatives Committee on Energy and Commerce and was lead negotiator for the landmark 1990 Clean Air Act amendments, which were the provisions that not only originated the Clean Air Act RMP requirements, but also the OSHA Process Safety Management Regulations and the establishment of the Chemical Safety Board, which was envisioned to be an analog to the National Transportation Safety Board, which investigates airline accidents. Chuck has advised clients on compliance and strategy related to RMP and has been counsel in enforcement actions involving the RMP program and Section 112R General Duty Clause. Chuck has been at the forefront of these revisions and the RMP regulations, scheduled for insurance by the end of this year, and advising clients on the PSM requirements as well. Chuck?
Welcome, everybody. And first, I want to thank Heather May and her team here at Hunton & Williams for putting this together. Similar to the topic we're going to be talking about, preparation and communication and planning, hopefully will lead to a seamless presentation for everyone today. As you all know, today we're going to talk about Are You Prepared? How to Respond to Industrial Plant Accidents Given Stepped-Up Federal Enforcement. The agenda we have today is, first, I'm going to set the table with the changing landscape, why it's changing, and some of the things to look forward to for the rest of the day, and also make some introductions for the speakers and manage the questions from you all. I want to emphasize what Heather noted at the outset. Please send questions in. We'll try to get to them, but if we don't, somebody on our team here will get back to you probably directly, maybe not just through email, maybe you'll get a phone call. So we look forward to your interaction. After I do the table setting, we'll engage EPA's National Enforcement Initiative and changes to EPA's RMP rule. Shannon Bruce will handle that piece. Then we'll do OSHA's increased enforcement and penalty structure. Susan Wiltsey here in DC will handle that. Then we're going to engage company responses to industrial releases. Tom Bohr out in San Francisco with Shannon will handle that. And then we're going to engage the Yates memo and how it impacts company investigations, when it'll occur, and potential responses for in-house counsel. Just to emphasize, the team we have here at Hunton is made up of a bunch of former congressional, that would be yours truly, congressional staff. We have former DOJ and EPA officials, former in-house counsel, leading RMP and PSM lawyers at a major company, and then all our lawyers that are working in the EPA, RMP, OSHA, PSM space, both advising companies proactively and then responding to incidents and enforcement and the like. Why we're here today is the fact that the landscape is changing with respect to incidents. It's changing with respect to the laws that will be applicable to companies on how they undertake measures to prevent and address incidents. And it's facing a changing landscape in the enforcement arena as well, with a number of initiatives out of the federal government and state and local governments to coordinate their information sharing, to have inspectors that may show up at facilities, look for things that are outside of their straight line jurisdiction. These are pilot programs emanating out of the Executive Order 13650. The social media and the 24-hour news cycle has implicated these both large and small incidents in a way that was not around with respect to how this all happened. The landscape's changing. I want to spend a few moments talking about how we got to the current landscape and the forces that led to changes, and that would then allow folks to address practical advice for you all on how to shape your in-house planning and responses. Taking folks back a long way, incident regulation and management at facilities is in large measure driven by past incidents. I think the Bhopal disaster, captured the attention of the world when the methyl isocyanate, cloud led to so many deaths, so many long-term injuries, and it really changed the way the governmental entities were going to interact with these types of industries that could cause this type of disaster. Again, I just want to note if with the news cycle today or the social media that we have today, we see incidents that result in no fatalities, perhaps some hospital runs and the like. The attention they get is more pronounced in some ways than that disaster back in '84, just because of the way the information flow goes now. Following that, we had Mexico City with an LPG terminal, another many casualties, a lot of property damage. In 1989, the P66 Pasadena facility, again, many deaths, a lot of damage. Interestingly, the FEMA report that came out in 1989 praised the company and indicated that the response was very fulsome and that nothing more really could have been done on the response side of the ledger. But nonetheless, the incident occurred, and it helped pave the way for the responses that we saw throughout the 80s, which was information gathering and report preparation. The reason I mention that is it leads to, it laid the foundation for the legislation that occurred in 1990. There were a number of things that happened, and the past is sometimes a prologue for the future, and just want to note that. The states were New Jersey, similar to a pilot program it's doing today on how enforcement should be conducted, and standard operating procedures should be undertaken. New Jersey created a state program. EPA had survey programs looking at release information. The OSHA also instituted what was called then the Chemical Special Emphasis Program, and it had detailed investigations on some 40 plants. This all happened in the 80s, and that led to then federal legislative response. In '86, we had EPCRA, Emergency Planning and Community Right to Know. It dramatically changed the level of information that communities had access to with respect to facilities in their communities. Then we had the 1990 amendments. Now, the 90 amendments covered many, many things, all manner of air emission regulation, ambient standards, air toxics, Title V permitting, lots of things. And this piece of it was held until the very end of the 90 amendment negotiating process for a number of reasons. And when it was engaged, it was done in a rapid fashion near the end of the process. It did not have the same level of back and forth and negotiating word by word that some of the other sections had. But it's important to note that what was in the 90 amendments laid the foundation for the enabling statutory authority for both EPA with the RMP program and for OSHA with the PSM program. You say OSHA is the Clean Air Act amendments in 1990. Well, the amendments had a number of provisions that were outside the Clean Air Act, but they were done at the same time as the other pieces of it, and they were all negotiated together. The provisions that were most impactful on the 90 amendments, 4 of them, the General Duty Clause, which you're going to be hearing about later, the Risk Management Program, which was developed through the 90s and then is currently under significant review, the Chemical Safety Hazard and Investigation Board, the CSB, that was created by the 90 amendments. And then you have the OSHA Process Safety Management Program. The OSHA statutory authority was embedded in the 90 amendments as well. What happened? Well, throughout the 90s, there was a period of stability in regulatory development, a progression of regulations throughout the 90s. There was performance standards created, industry responding to the new regulations or forthcoming regulations, developing the beginnings, or enhancing the safety cultures that were already there. That all happened in the 90s, early 2000, and companies had established programs that they could rely on. What happened then, again, pointing to incidents that drive processes, the BP Texas City incident. I have these on this slide to bookend BP and West Texas fertilizer plant, separated by 8 years, and in between there were a bunch of others that folks on the phone are some very intimately familiar with, some just in passing. But I note these two because they were clearly news-capturing incidents and they provoked policy outcomes. The BP Texas City led to the famous Baker panel. CSB recommended that the panel be set up. Howard Baker put that together. It culminated in a series of 10 very far-reaching recommendations that have been driving RMP and PSM regulatory performance at facilities since then. The West Texas plant led to the Executive Order 13650 by President Obama. This executive order set in motion a number of activities within the federal government and working out with state and locals as well. But on the left side here, I wanted to emphasize a few things. Improving operational coordination between federal, state, and local partners and enhancing federal agency coordination. That has led, as I noted earlier, to pilot programs and other things on sharing information for enforcement and response. And I think more to come. The results of those pilot programs are important to track. Then the one bolded, modernizing policies, regulations, and standards, this executive order has led to the reworking of the regulatory environment at EPA for RMP and at OSHA for PSM. You'll be hearing more about that. So, what are we seeing with this kind of changing landscape with respect to incidents, response, and enforcement? We widely noted in trade press, many folks comment on the fact that there appears to be an increased criminalization of incidents. The fines are substantial. Injunctive relief or injunctive demands in these settlements is significant, even if there aren't any criminal charges pursued. There's an increased targeting of corporate officials, and there's an increased targeting of lower-level employees, and there's increased exposure on tort actions. There's obviously high risk of harm to companies' reputation, and what we see is a plethora of agencies involved in all of these incidents. So what do we have as a challenge for those on the phone today and those of us that work in this space and try to assist them? We obviously have a goal of minimizing the risks of the company right after the incident. Best way to do that, obviously, is not to have the incident. So there's a whole front-end loading piece to it. But then what do you do after the incident? Then you have internal and external investigations that are going in parallel. And we're going to, the anchor leg of today's talk will get into the Yates memo and how that may be affecting the response and interviews post-incident. With that, I'm going to now turn it to my colleague out in California, Shannon Bruce, managing partner of Hunton's San Francisco office. She's a former chemical engineer in the oil industry, and she's, for a number of years now, been combining her technical expertise and legal counsel skills to help clients on a wide range of matters for internal company compliance, but also with the courts and the agencies. She was former executive counsel for GE and was responsible for litigating in the 90s challenges to the 112R RMP program and successfully resolved that lawsuit. And since then, she's been advising companies on compliance with 112R and PSM and in handling enforcement matters. Recently, she's also been on the forefront of negotiations with EPA on the new RMP rule and the fallout from Executive Order 13650. And she's also very active in the parallel regulatory work that's underway out in California. Shannon?
Thank you, Chuck, and good morning if you're in California, and good afternoon if you're on the East Coast. I'm going to speak directly to the National Enforcement Initiative and some of the aspects of the upcoming RMP regulation changes that in-house lawyers need to be thinking about in terms of the revisions to the existing programs and how you'll need to manage risks when legal risks when incidents occur. So we'll start with EPA's National Enforcement Initiative. This is the first time, I believe, that reducing risk of accidental releases at industrial and chemical facilities has been on EPA's three-year priority list. It's on the fiscal year 2017 to 2019. We're in fiscal year 2017 right now. And I put this up here because it's pretty instructive to know what you're facing, and EPA's problem statement is that thousands of facilities nationwide with an environmental justice angle, in low-income or minority communities are making use of extremely hazardous substances, and that there have been 150 catastrophic incidents a year that result in fatalities and serious injuries, evacuations, and risk of harm to health and the environment. So if you look actually at EPA slides for the small business regulatory enforcement panel that they used with the RMP rule, the actual number of fatalities and serious injuries per year is much less than that. And if you look at this list, that's why it says risk of harm to health and the environment. But their goal statement is that they are going to focus on reducing the risk of accidents through innovative accident prevention measures and improving response capabilities. And you can tie that back directly to the executive order that Chuck just mentioned with respect to improving response capabilities. And in fact, we have seen EPA this year doing a lot of outreach to local emergency planning commissions, bringing different folks in industry in to talk about how some of the existing response capabilities and communications can be improved. So beyond just the regulations, they actually are putting some effort into that. And communication, as you all know, and Tom will get to when it's his turn to talk, is key in responding to an incident. So it also follows OSHA's National Emphasis Program, which came out in 2011. Now, what I thought was interesting and wanted to point out to you guys is the focus, the way that EPA is phrasing these issues. It is all too common, an all too common occurrence for industrial facilities to have serious accidents and explosions. And obviously everyone believes that even one serious accident or explosion is too many. But the messaging around this is important, and it's important as you think to respond to these things when they happen, how you have to be prepared and how you have to respond. So, and there are other key messages that these are preventable if the necessary precautions were taken and if you all were using common sense. So a targeted focus of EPA is going to be on the facilities and the chemicals that they believe pose the greatest risk. So it's just, that's from the proposal that they issued, and then with the final, they just put out the final things. So what do we expect to see? We expect to see EPA's Criminal Investigation Division personnel, in addition to the other alphabet soup that Tom will talk about of agencies that come out, continuing to be among the government personnel that are going to be first on the scene after you have an incident. And you combine that with the worker endangerment initiative that DOJ and the Department of Labor, and Susan will speak to that as well in more detail, are going to continue to influence activities. And you all need to be aware, while not scaring people, that there are potential criminal charges, and Tim will get into this in more detail, under Section 113 of the Clean Air Act, which relates to negligent and knowing endangerment. So even negligence under the Clean Air Act can lead to criminal penalties. And with respect to the Occupational Safety and Health Act, that's been a sore spot for a number of years, that they don't have as much criminal and civil authority as they believe they should have. And so a lot of times it reverts over to the Clean Air Act because, as Chuck said, that's where 112R got placed after those incidents in the 80s, and that was shoved into the Clean Air Act, and so now it's subject to it. And then the prosecutors' go-to opportunities for crimes are always false statements and obstruction. So what are we seeing in terms of the greatest risk areas right now, given that the 112R is generally currently a performance standard, and we'll talk in a minute about it getting more prescriptive, is the 112R1 general duty. And that is a statutory requirement that became effective November 15, 1990, when President Bush signed the bill, the first President Bush. There's no list of covered substances and no threshold quantities. So you guys are all aware that the RMP rule establishes threshold quantities of pollutants, and everybody worked very hard to get below those threshold quantities if they had the extremely hazardous substance on site. But even if you did that, you still are subject to the general duty. And while there's no reporting requirement and information sharing with the public is not required, there's also no exemptions or exclusions. And so over the years, that has become, and I'll have a slide that shows you how EPA has to enforce the general duty in just a couple moments, but this has become a go-to opportunity. So for the government in both civil, criminal, administrative enforcement, even their, basically ticket writing that they give, they really do go for the general duty clause. And so as in-house lawyers, you need to be aware of what the criteria are. So these are the requirements that the general duty clause imposes. It's to identify hazards which may result from releases of extremely hazardous substances, using appropriate hazard assessment techniques to design and maintain a safe facility, taking such steps as are necessary to prevent releases and to minimize the consequences of accidental releases which do occur. And importantly, it's to be interpreted the same way as the OSHA general duty clause. And I'll get into that in a minute in more detail. Two important things, and I'll give Chuck Knaus a little credit for these because, well, he told me and I wasn't there, but he says that he insisted that to sign off on this provision, since he was one of just a few people required to sign off on every provision of the Act in his role as lead counsel, that you could not create citizen suit liability and you could not have a general duty violation cause be the basis for tort liability, effectively, and nuisance liability. And so that is the basis of these two provisions. So that's a little bit of the bright side there. So as I mentioned earlier, the scope of the general duty clause is that it's extremely hazardous substances, and it includes but is not limited to the RMP list of toxic and flammable substances. So what's interesting, and that the in-house folks who are implementing this program, whether you're a lawyer or an engineer, you need to be aware of is that EPA has issued some guidance around the general duty clause, and I just noticed the difference in how they view the language. So OSHA says an employer shall furnish to each of his employees employment and a place of employment which is free from recognized hazards. And EPA says owners and operators must maintain a facility that is free of a hazard. So the recognized is gone. Then the hazard must be recognized. Then they go to that and they bring recognized there. But the way that they interpret it is more of an obligation on you than otherwise. And then they go to harm as opposed to death or serious physical harm. And then also the owner or operator can eliminate or reduce the hazard instead of it's feasible to eliminate or materially reduce the hazard. So I just note this difference, and we often hear and experience that OSHA is viewed as a more moderate agency in terms of taking a practical approach and really trying to get in there and help companies solve problems. Some people may have different views of that, but compared to EPA, you just see this difference in approach, just even in the guidance document stating what the general duty clause is about. So here's an example of EPA's interpretation. They have a guidance document for implementing the GDC in the Marcellus Shale, and they say, that a facility installed a water-based fire suppression system in storage areas that contained water-reactive chemicals. This created a clearly hazardous condition, and they cited the company for that. I just think it's worth noting the types of things that EPA is citing to. So are they really enforcing this? And here we just took a few enforcement actions that cited the general duty clause over the last 5 years. And you can see that some of them included some fairly significant fines. Now, most all of these were coupled with claims of violation of the Part 68 rules, which is the 112R7 reference, and some with notifications under EPRA and Circle 103. But what's important to note is that even this single, where it was only a general duty clause violation, was a $100,000 fine. So you're looking, they always throw the general duty clause in because if they can't prove a specific violation of some of the detailed technical regs, because it is a performance standard, they feel that they can use that to leverage significant fines. So even if nothing happens with the federal rules that apply to you or your local state rules, the general duty clause is continuing to elevate. And if you look at the numbers from before 2010, they weren't nearly so high in terms of what your risk area was. Oh, and also just this chart, and I can go backwards, I think. This does not include the significant injunctive relief that was included in a number of these consent decrees, including supplemental environmental projects and commitments to conduct audit programs and have third parties come in and monitor their behavior subsequent to the signing of the consent decree. So it's important to keep in mind this general duty clause and RAGAGEP crosstalk and how you can think about what are similar businesses doing to minimize the hazard. The folks that are in the refining and chemical industries are well used to this, looking at API standards and other standards, but EPA has started putting out safety alerts, and their range of sources of RAGAGEP that are now being touted both by EPA and out here in California in some draft regulations that are currently being brought through that could significantly expand the scope of RAGAGEP. And even if you aren't subject to the main 112R regulations, or you have a process that isn't in the PSM program, this general duty clause, you could find yourself caught in between. So I just want to briefly address, I could talk for probably 4 hours and put you all to sleep on EPA's proposed RMP rule revisions, but I wanted to point out, and these are the main elements, I do want to speak just to two provisions that I think will significantly impact how you guys think about your RMP compliance. One is the third-party audit, and EPA is proposing that would be triggered by a reportable accident or a determination of noncompliance with 112R. And in the preamble, they spoke to significant noncompliance, but they actually didn't put that in their proposed rule. I know a number of people commented on that issue, and hopefully that will get resolved. But those are fairly quick triggers because of the way they have redefined a catastrophic release to include a number of things that would never have been considered, but just plainly wouldn't be considered catastrophic under any reasonable reading of that word. But they've redefined that now in the proposed rule. If that were to go final, you're going to have these third-party audits more often. And what's going to happen is that you're going to have a third-party audit. Those people are going to want to justify their presence, so they are going to make findings, and let's face it, nobody's perfect. And then you have to create a findings response report that you will then send into the agency. And if you have a situation where you submit that findings response report and then you have an incident, you have to be prepared for the fact that those documents are all going to be pulled out, and your response and whether you did what you said you were going to do in response to that audit finding or whether you disagreed with that audit finding, all of that documentation is going to feed in with 20/20 hindsight into your analysis, their analysis of your liability. And so there's a lot more to say about third-party audits and the issues with the rule, but just for purposes of this webinar, that's the issue I wanted to bring up. The other thing I wanted to make sure folks were aware of is EPA proposed to require disclosure of a host of information to local emergency planning commissions, and who are largely volunteers or even your competitors, and they are going to require the accident history information, compliance audit report summaries, incident investigation report summaries, and those types of documents, the summaries. So you're now creating a new document that summarizes what your incident report was. And again, if you have an accident, all of that stuff is going to be reviewed with 20/20 hindsight and scrutinized. So my message to you is that as the in-house folks responsible for these things, you want to be reviewing these documents as they get created in all your spare time to figure out if something were to happen, think about how that would be viewed and make sure that the language is appropriately conservative, not inflammatory. You often, just as we've all had situations where you get some email, I can't believe that guy's not doing what I told him we absolutely have to do. Those kinds of things will not be helpful in the long run. So with that, I think I can turn it back to Chuck to introduce Susan.
Hey, thanks. Thank you very much, Shannon. And next up is Susan Wilsey, who's going to talk about OSHA's increased enforcement and penalty structure. Susan is head of our DC labor and employment practice with over 25 years of experience in enforcement actions regarding OSHA and the Mining Safety and Health Administration. That work's included a lot of work in the PSM area. She's also been very involved in giving compliance assistance, training, citation defense, creation of oversight, and oversight of PSM and general OSHA audit programs, and been involved in fatality and serious injury accident investigations. She's also been admitted to the College of Labor and Employment Lawyers as a fellow, which is quite hard to get into because it requires recommendations from folks that you have been up against in adversarial proceedings. That's kind of cool. So Susan?
Thank you, Chuck. Good morning and good afternoon, everyone. I'm delighted to have a few minutes to talk about OSHA, which, as those of you on the call who know me know, is one of my favorite subjects. The latest news on the OSHA front is the increased penalties. As I think most of you know, they went into effect on August the 1st. What was stunning about that week was suddenly every OSHA investigation that we had pending came to citation remarkably that week of August the 1st, because OSHA made a decision that anything that was pending that wasn't yet cited could be cited under these new penalties. So it was a big week. The penalty increases, well, they could have been worse, but they're not great. Serious went from $7,000 to $12,471. Now that is, of course, the cap on it. You can get your good faith reductions and the like, and we always try to do that. And then the rarest of birds these days, the other than serious citation, which we almost never see, that also has the same penalty structure. Willful and repeat went from $70,000 to $124,709 per violation. And if that number isn't stunning enough, I want to remind you all that OSHA still has its egregious penalty by penalty approach to some situations such as PPE violations, where if they find your violation to have been willful, they will cite you for every worker that was wearing insufficient PPE. And because you're already willful and now you can do the multiplier, we're now looking at a multiplier of close to $125,000, which really will be a stunning change from what we've seen historically. And then failure to abate has always been a terrifying citation because those are assessed by day, and those have gone from $7,000 to $12,471. Again, the max, we can slice some of that off, but it still isn't pretty. This is the floor for state penalties. Some states already were significantly higher in terms of their penalty structure than the feds. I'm looking at you, California. Many of the other states will follow suit. As you know, there are many states that do, state plan states that do like to work cooperatively with employers and are really chafing at this mandate from the feds. The Severe Violator Enforcement Program, it's been around since the 2010, 2011. I think it's important to throw that in the mix here, not just because it's still there and still significantly problematic, but also because of the announcement last month that OSHA is having a whistleblower severe violator enforcement program as a pilot now, but we do anticipate that the pilot will become part and parcel of the existing SFEHB program. And just as a brief recap, I know that none of you on this call work for companies who are SFEHB, and I know that I do everything I can to make sure that that's never going to be the case. When an employer is classified into the SFEHB program, they are then subject to enhanced mandatory follow-up inspections at the facility where the citations emanated from initially, but also OSHA and State Plan OSHA then has the authority to inspect without notice for any reason that they want to. It's basically the at-will component of OSHA enforcement, any site in the country within the same corporate enterprise. And of course, there's enhanced abatement and settlement terms associated with these SFEHB citations. Lately, that mostly looks like you have to hire an outside consultant, which adds an additional cost into this mix. And the piece of the SFEHB program that causes everyone the most grief is the aggressive public shaming part of it. As Secretary Michaels said 2 or 3 years ago at a conference I attended, what do you do when you encounter a mountain lion in the woods? And his response was, you try to look bigger. So the aggressive public shaming piece is that was his mountain lion metaphor. He wants the agency to look bigger than it is by publicizing on the website immediately after citations issue the most damning press available. And that press release is never amended. There's never a correction. We all know that most OSHA cases settle on much more favorable terms. I have been successful every single time one of my clients have been classified as SFEHB of removing them out of that program through the informal conference. But yet, sitting there on the web page is this damning press release that takes many years and a lot of PR effort to overcome. The way that one gets into SFEHB, I won't go through all of the entranceways, but for purposes of today's call, one of the ways that you can become SFEHB is to have 3 or more citations that are willful, repeat, failure to abate that result from gravity serious violations related to a PSM incident. OSHA criminal risk The thing that's interesting about OSHA criminal risk is the press and OSHA's press and OSHA and EPA's press all has to do with what's going on at the federal level, whereas the biggest news is what's going on at the state level. But let me start with the OSHA criminal risk at the federal level. The OSHA Act is a significantly tamer criminal vehicle than any of the environmental laws. In order to be criminally prosecuted under OSHA, you first have to be an employer, which is not individual liability except in the rarest of occasions. You have to have experienced a OSHA violation that directly causes death. So you have a very clear causation piece. That causation and that hazard had to result from a deliberate act. And under OSHA, that deliberation has to be both a knowledge of the hazard and a knowledge that the hazard violated OSHA. So you can see just how difficult it is to get traction for criminal prosecution under this act. Indeed, there's an average of 13 workers that die every day at work, which is stunningly horrible. In the history of the OSHA Act, which has been now over 40 years, there have been fewer than 80 criminal referrals that are specifically under OSHA, and those have resulted in fewer than 15 convictions. Now, that is not in any way designed to lull you into complacency. There's a lot of other ways to be criminally prosecuted for creating and not resolving hazards in your workplaces. Of course, there's the perennial "don't lie to the government" rule. That's that's Section G of the Act. People and companies are regularly prosecuted under that provision. And it wasn't an accident that I said people and companies, because most of the individuals and entities that are prosecuted under this provision are small companies, largely construction companies. And when the business is operated akin to a sole proprietorship, the business is the person and the person is the business. So people have gone to jail under this provision. The OSHA Field Operations Manual also instructs OSHA inspectors to utilize generally applicable criminal statutes to address misconduct, and that happens. But as I said, what happens far more often is the utilization of state criminal laws of general applicability. And later in the presentation, there's going to be quite a bit of conversation about PR concerns and the like. And here is where PR definitely will matter, because the individuals and companies that end up being prosecuted under state law often are small towns and outrage from the community about one of their own being injured or killed. The Worker Endangerment Initiative, which Shannon referenced earlier, is another initiative between DOJ and DOL to try to increase federal level enforcement of OSHA crimes. This has happened, this type of initiative is not new. It's happened a number of times over the years. There often not too much traction on it. We'll wait and see on this one. This seems much more coordinated and focused than ones in the past. On the Department of Justice's website, they list these two cases as examples of the Worker Endangerment Initiative. However, both of these cases, obviously, if they've gotten prosecution in 2016, well predated the 2015 announcement of the new initiative. And then just before I turn it over to my colleague Tom, let me give you just some quick tips on the specific OSHA issues following a fatality and a serious injury. Of course, there are the reporting obligations, any hospitalization other than for observation, and any fatality, any amputation, any removal of an eye, and the like. Please note that the state reporting obligations are often stricter, and you should not rely on your knowledge of the federal law only. And then, as you know, those of you who know me know, my guidance is always to cooperate with OSHA. That sets the table for everything that happens thereafter. In a catastrophic situation, you're going to want to, unless the government's being completely unreasonable, you're going to want to reach an informal settlement agreement with the government that has favorable language with respect to the way that citations are articulated and favorable non-admissions language. It's going to help you a lot in what happens down the road. You'll have to carefully manage the injured and the decedent families. They aren't the enemy. You'll want to accelerate the workers' comp process, get money to the families as soon as possible, and if co-workers and management level want to reach out to the family with casseroles and visits and the like, please do let that happen. Finally, just the multi-employer site issue. And when I'm wearing my labor and employment hat, multi-employer site issues are the hot topic of 2016, and I'm certain also will be the hot topic of 2017. In the OSHA space, all work sites are multi-employer and everyone is equivalently guilty. So OSHA will now cite all employers, and they'll do that purposefully. It's a stated enforcement approach. They're doing that to create peer pressure so that employers will address the issues going in advance of a problem, and so everyone, a rising tide raises all boats. In the interest of time, I'm not going to go any further into that, but I will leave you with, in a catastrophic event, the most important consideration will be the lawsuit from the contractor employee who was injured or if killed, that family's estate. There is no workers' comp bar that prevents that litigation from going forward, and everything that you do in terms of planning for the hopefully unlikely event of a catastrophe should also keep in mind these other players in the mix, and your contracts with your contractors and your vendors and your temps all should plan for liability in these instances.
Hey, thank you, Susan. Up next is Tom Bohr. Tom is 10 years as a government lawyer, split between DOJ enforcement and EPA. He has experience representing clients in all manner of industrial incidents. He's involved in internal investigations, notifying agencies of releases, assessing compliance with EPA and OSHA's requirements, resolving enforcement actions, defending third-party actions, pursuing claims against insurers. Quite a broad background that Tom brings, and he has a lot of practical experience in advice regarding the handling of incidents. Tom?
Great. Thank you, Chuck. Hello, everyone. So I'm going to speak about coordinating legal responses to industrial releases. This is a pretty broad topic, as I think most of the topics we're covering on this webinar are. I could certainly speak for hours about this, and I think I have just short of 15 minutes. So what I'm going to try and do is really tailor this discussion to highlight the issues that in-house counsel need to be thinking about, and kind of go over those key issues. And I think that will give some perspective. And obviously, for those that are interested, I think that, we obviously would be available for follow-up discussions. And, we often go out to client sites and do CLE on incident response that would go into much more detail over these various issues I'm going to cover today. Before I continue, I have been told that in order to get CLE, you need to jot down this code, which is up on your screen, Enforce 518. And at least for those in New York who are looking for CLE, you will have to report this code in order to get the CLE credit recorded. All right, so as has already been highlighted, release situations are particularly high-stake threats to companies. And, I would take the position, and I think consistent with what we're seeing, those stakes have increased for a number of reasons. I think that release incidents present unique challenges to organizations and companies that may be different from what, or almost always different from what companies handle in the ordinary course of business. I think they present multifaceted risks And generally, they put in-house counsel on the front lines of having to make a number of decisions, ideally in coordination with experienced outside counsel and with incident commanders, but perhaps much more so than would occur in the ordinary course of business. They really demand a coordinated and carefully managed response, and as I'll discuss as we get into these slides, the key to that really is preparation. We're seeing environmental emergencies having a higher and higher profile. As Shannon was talking about, when you look at how EPA portrays catastrophic release situations as being all too common, as being preventable, that's how the agency is going to generally enter into framing its response to release situations. And I think it's how the media, in particular the social media, is picking up on these issues. So generally in response to a release situation, it's not going to take long for a company to be on its heels potentially and being accused of putting the public into danger, regardless of how diligent the company may have been, regardless of how much of an accident it may have been. It's something that companies need to be aware of. Generally, harm is obviously going to drive media attention and regulatory attention, but the perceived risk of harm is also going to drive that attention. And there can often be a pretty substantial disconnect between the perceived risk of harm and the actual harm that the public may be exposed to. As was discussed in the OSHA context, and as Tim will speak to in a moment, we certainly are seeing the risk of increased criminalization of incidents by the government. It's something that companies need to be aware of and manage, I think, from the very outset to try and get incidents off of a criminal track with the government. And regardless, exposures to civil penalties and injunctive relief for incidents are also significantly increasing. EPA, with its new national enforcement initiatives, has made clear that they see RMP and catastrophic release enforcement as a priority for the agency. Although the number of cases overall being brought by EPA for environmental violations is declining, for incident and kind of high-profile release situations, there actually, I think, appear to be increased staff and attention by agencies, so you can expect more scrutiny. And the injunctive relief can be really substantial. You saw the penalties that Shannon put up earlier for RMP-type violations. But injunctive relief being required by agencies, particularly under EPA's approach of trying to prevent incidents in the future, can expose companies to very, very high costs in order to resolve incidents in settlement with the government. And we've seen situations where entire processes have to be re-engineered and redesigned in order to reach a settlement for a release situation with the government. And then you have the reputational harm to companies from the increased government and media attention, and the transaction costs, which can be quite significant when these matters continue for long periods of time. So, generally there's really a spectrum of what we would consider incident response, and that can start kind of on the most extreme end with what everyone thinks of and what we're really focusing on today when we speak about catastrophic situations, which are explosions and fires. But that really is on a continuum, and it can start from things along the lines of a search warrant being served on a company's facility, information request letters being sent to a company, and an unannounced inspection. And the question is, how trained are in-house counsel, how trained are your facility staff that are going to be sitting in the facility if EPA shows up unannounced for an inspection in order to handle that? And so it's very, very important to think about the full continuum of incidents and how prepared staff may be to handle them. Even on the kind of more traditional severe incident response, there's a continuum. And I've just listed these two examples here. We've already talked about West Fertilizer. But the point is, with West Fertilizer in Texas, that was a very traditional explosion. The media coverage was substantial and quick. The enforcement response was equally substantial and quick. The end result is essentially the company had no facility left to operate, but really with this type of incident, it was unlikely that they were going to be able to easily recover. A similar outcome, but very, very different circumstances, looking at Freedom Industries in West Virginia. I mean, here you had a leaking storage tank that had been leaking potentially for quite a long time. There was never an explosion. There was just this leak, but the moment that it was identified, you had a massive media response, a massive regulatory response, ultimately putting the company into bankruptcy and leading to criminal charges. So it would be, it would be incorrect to assume that it's the fires and explosions that are really the company type of situations. There are plenty of other incidents that can lead to substantial enforcement, and companies need to be prepared for. And that's basically what I'm intending to show here in terms of the kind of continuum of incident response. And when you look at number one up in the upper left-hand corner in terms of prevention and mitigation, I think this is really, an ongoing process that many companies should have in terms of evaluating their processes, evaluating their inputs and raw materials, looking at their capital expenditures and capital improvements, and how does basically a company minimize its risk. Generally this is a business side decision, but I think in-house counsel can have a lot of input in terms of making the business understand perhaps the other long-term benefits that can accrue from engineering changes or process changes at a facility by reducing exposure to significant incident response situations. Next, in blue, you have preparedness, and this really is the training. What training is going on, what drills are companies performing in order to prepare for an incident, for a potential incident. Then, hopefully avoided, but even the best run facility can end up in a situation where there is some type of incident. And once that incident occurs, you enter into the response phase, which I'll talk about more in a moment. But what I want to emphasize here is really the importance of both scalability of the training and preparation and flexibility of responding. So in terms of scalability, incidents come in a wide variety of sizes and flavors, and it's important basically that the training and preparation prepare counsel and prepare facility staff to respond to all of those. And I think really importantly on flexibility, it's basically having an internal process once an incident occurs in order to change the circumstances of the incident. And so you could have a very, very substantial incident that perhaps because of its geographic location, perhaps because of the promptness and success of the response, does not cause a significant government response. You also could have a minor incident that, because of the geographic location, results in a substantial response, and you need to scale up quickly for that. Looking here at before getting started, preparation is really key. And there are a number of steps that can be taken to reduce the likelihood of an incident or to at least mitigate the potential negative effects of an enforcement action. I've listed a number of these here. I think what I really want to emphasize are just a couple of issues on this slide. One is the importance of including facility staff on talking about the key legal issues that may come up in terms of an incident, and I'll get into some of those issues on the next page, but so that folks are aware of the types of issues that will come up and where they should be contacting in-house counsel quickly. The other issue is, under the RMP program, you're going to be required under the statute and regulations to develop emergency response plans and to have incident commanders, but I think that the other thing that's important is for companies to go beyond that and really look at putting together, legal, public relations, and community outreach teams and plans that can be implemented the moment there's a substantial incident. You don't want to be in the position of identifying outside counsel, figuring out who it is that's going to reach out to local governments after an incident has occurred. And finally, in terms of preparation, I think that one key warning that in-house counsel need to keep track of is that it can be very good to have plans, for instance, to do additional audits to ensure that you're in compliance with RMP, to have additional requirements at a facility in terms of outreach, in terms of training. But if you have that written down, it is very, very important that you comply with the company's own internal policies, because if you do not comply and there is an incident, the fact that you had internal policies that were not complied with will be held against you by the government and will increase your exposure to penalties and potentially even criminal proceedings. So, in the first hours of an incident, the key priority for any company is going to be stopping the emergency and protecting or mitigating the threat to human health and the environment. Obviously, reporting the release as required by law is going to be urgent. One issue in terms of training that's very important for facility staff is really emphasizing that calling 911 is not enough, and they need to call the National Response Center, local authorities as required by law. They may need to loop in in-house counsel and potentially outside counsel to identify reporting requirements. What's important to remember is that reporting violations, even what some may consider minor violations for an incident that's under control and perhaps the National Response Center is called only several hours after the incident occurred, can still result in tens of thousands or even hundreds of thousands of dollars of penalties. So it's very important in order to comply, and something that can be dealt with easily with training. The role of counsel, both at this point in the incident response and as we get into the next slide, I really see three parts. One is to comply, to make sure the company is in compliance with all requirements. The next is to protect the company's interest, whether it's to protect privileged information, to protect reporting obligations, and then finally is to serve as a check for the ongoing incident response. So whereas many folks that are involved in incident response are going to be wearing a single hat, such as the incident commander, document custodian, the public relations official, the in-house counsel is going to have a check on basically processes that all of those individuals are involved in. So in-house counsel and outside counsel are going to be involved in all aspects of incident response, and it's going to be necessary for them to identify legal issues throughout those aspects and make recommendations for how to proceed across multiple areas. So these are some of the key legal issues that come up in terms of incident response. And a couple issues I just want to highlight here. In any incident, you're going to have a number of agencies that are going to respond. You're going to have investigatory agencies like the Chemical Safety Board, NTSB. You're going to have civil agencies potentially investigating civil regulatory enforcement like EPA, OSHA, state and local agencies. We've seen situations where you might have 4 or 5 different agencies show up within the first 24 hours. You have criminal agents particularly involved, whether it's the CID from EPA, the FBI, the district attorneys from the local jurisdictions. And you really need to basically have a plan to deal with all these different agencies. All of the agencies both have their own duties to perform, but they all have a need to justify their continued existence. So they're all going to be trying to push their particular agendas, which may obviously be inconsistent both with the company's interests, but also with the agendas of other agencies that are showing up at the site to perform investigations. I think another key issue is you really want, from the very outset of an incident, to try to minimize the risk of criminal enforcement. And obviously there's only so much that can be done, but there are important things that need to be done. One thing is that government is going to pretty rapidly form a theory in terms of whether the company is acting in good faith or in bad faith. And you really want to convince the government quickly that the company is doing its best and acting in good faith, because it's hard to shake the government off of a bad faith theory once that's become an entrenched operating paradigm for the government. And also, I think most importantly, actions taken after an incident can both really increase the risk of criminal enforcement or increase the exposure of criminal enforcement. So issues like obstruction of justice, lying to the government under 18 U.S.C. 1001, it's all critical for in-house counsel to be keeping an eye out for these issues and avoiding it. And in terms of what we've seen, there can be a lot of circumstances where these issues arise that are not due to anything negative by the company, but you may have individual employees who are trying to protect themselves or think they're trying to protect the company and lie, and that will be imputed to the company even if the company had nothing to do or actually was advising employees otherwise. It's also very important to look at internal investigations. You may be required by law to perform an investigation, but we generally would strongly encourage conducting a privileged and confidential investigation under the oversight of counsel. It's critical that companies, as quickly as possible, get a firm grasp on all of the circumstances and facts underlying an incident so that they're able to construct a good response, both in terms of mitigating the risk, but also in terms of how they respond to regulatory agencies and develop a public relations plan. So after an incident, reaching a resolution can be a long-term process, and it can require a multidisciplinary team to address. And basically, for any incident, you're going to need to scale your team and select who participates in the team depending upon the particular circumstances of the incident and what the needs are, whether or not there's insurance coverage that needs to be pursued, whether or not there are third parties that have liability to the company for their participation in how the incident occurred, toxic tort claims, business interruption claims. And this all ties back really to the flexibility and scalability of the response, which should be built basically into training and drills and preparation that was done beforehand. So this basically is a conclusion and summarizes some of the main issues that I hit on here. And really, I think the takeaway at the very end is, training, practice, and preparation are the key issues in order to be able to manage an incident. Every incident is going to be different, but the more prepared for these types of issues the in-house counsel are, and the more prepared facility staff are, the stronger the response is going to be when an incident does occur. All right. Thank you very much.
Hey, thank you very much, Tom. And two things before we get to Tim Hafey. One of our colleagues, Todd Michelow, was pulled out of the country to handle an enforcement matter. Todd has DOJ experience as well as serving as judge advocate in the Coast Guard, and he has experience dealing with spills and marine casualties and national security events. The other thing I wanted to note is we've gotten a few questions. Send them in now if you have some, and as I said, we'll get to them today or on follow-up. Tim Hafey is head of the Hunt and White Collar Defense and Internal Investigations practice. He has had big-time jobs. 20 years, 12 years as Assistant U.S. Attorney in the D.C. and Western District of Virginia, 8 years as U.S. Attorney for the Western District of Virginia, Chief Law Enforcement Officer responsible for prosecuting crimes. Obviously, vast experience, and look forward to hearing his comments today on the Yates memo.
Chuck, thank you very much. Nice to be with all of you, albeit remotely this afternoon or this morning. As Chuck said, my task is to talk a little bit about the most significant development in my world, the white collar investigations practice, which is the Yates memo. It is, as most of you know, a memo that was set forth to component heads and all U.S. attorneys just about a year ago from Deputy Attorney General Sally Yates, which outlines the department's approach to the investigation and prosecution of individuals within corporate investigations. It has led to a lot of commentary, a lot of discussion. What I want to try to do today is distill it down into some sort of practical advice for in-house lawyers who are dealing with these industrial accidents. Just a brief bit of context, the genesis of the memo really stemmed from criticism. The folks who lead big government agencies read the newspaper like everyone else, and I think Attorney General Holder at the time was sensitive to criticism that the department was not holding people accountable in the wake of the financial crisis in 2008-2009. He was formed a working group within the department. This is a very classic DOJ endeavor where every component who has any potential connection to an issue sends a representative to a group that then meets over a period of weeks and months to try to come up with a department-wide policy. And this was frankly a contentious discussion within the department. There were a lot of people involved in that working group who really didn't think that there needed to be any new policy because, of course, the department always considers charges against individuals in the midst of corporate investigations, and that by issuing a memo, you're sort of crediting the criticism, and that would be unfair. Others, including the decision maker herself, Sally Yates, disagreed and thought that it was important to articulate a clear policy that would give notice to folks like you about what the government expects when it comes to the evaluation of charges against individuals in these big corporate investigations. And the memo was issued in September of last year. The very basic terms of the memo suggest that prosecutors in U.S. attorneys' offices or within DOJ components, and that includes Environment and Natural Resources, must evaluate the exposure of individual employees within the context of these large investigations of companies. The corporate defendant cannot obtain any cooperation credit unless that company discloses all relevant facts about culpable individuals. What this means practically is that when these corporate investigations take place, there either need to be charges against individuals filed or an explanation as to why no individuals are being charged, and that those explanations are evaluated by folks up the chain at the Justice Department. And then significantly, this applies in both the civil and the criminal context. The department wants individuals to be evaluated for sanctions within civil investigations as well as criminal. Now, the heart of my comments here deal with practical manifestations of the Yates memo. What have we seen in the year since the Yates memo was issued? Well, we're seeing more lawyers for individuals in the midst of these investigations. When a company is being investigated, there are earlier decisions required as to whether or not individual employees need their own separate counsel. Sometimes those decisions are made independent of the employees by in-house lawyers and working with their outside counsel for the company. Sometimes employees themselves say, hey, I heard about this memo, do I need a lawyer myself? But the key point here is that these decisions are reached earlier and are now, in my experience, being answered more often in the affirmative in terms of whether or not individuals need outside counsel. My strong advice to company counsel is that you start with the presumption that the interests of the individual employees and the company are aligned, and you actually affirmatively begin with a joint defense agreement. It is not at all impermissible, which frankly would be expected by the government, that there would be a JDA in place that allows employees, counsel, and counsel for the company to share information within the privilege about the nature and the facts developed during the investigation. Company counsel should also generally assume indemnification for those attorneys unless and until adversity between the employee and the company appears. Of course, if these are current employees, then the company can compel an interview and disclosure of information. Although that then gets us into the realm of the upjohn warnings. Very standard part of white-collar practice is to warn an individual employee that you represent the company, not that individual employee. The privilege is held by the company, and facts disclosed could be provided to third parties at the discretion of the company. That, while pro forma, now raises alarm bells and maybe has more relevance given the fact that individual employees themselves are being evaluated for potential prosecution. An attorney who's involved for that employee may thwart access to that client, may say, I don't want you to talk to my guy because he may very well have a Fifth Amendment privilege. Now again, if it's a current employee, then you can certainly compel him or her to provide information. But there are times when that individual himself or his lawyer may believe that the Fifth Amendment issue is more and powerful incentive than the employment. And you'll see employees stepping away from their jobs in order to protect their ability to resist those interviews and not provide information. This makes internal investigations potentially more difficult because, again, your job as company counsel is to get the facts, is to evaluate exposure. You need information to do that. And if there are lawyers involved who are not focused on your goal, but rather focused on protecting the interests of their individual clients and are concerned about information provided by their clients, that may be more difficult to obtain. So here, the bottom line advice is be mindful of that potential. Start in a cooperative posture. Try very hard to get JDAs and get information and do this in a collaborative way. But be aware that given the pressure perceived or real by the department to charge individuals, it may, depending on the lawyer or the employee, be more difficult to get. You're also going to see a much harder time getting agreements to resolve these cases that are global. that resolve the investigation of the company and all its individuals. What we're now seeing, even since the Yates memo, is the resolutions with the company that actually require the company to cooperate, to continue to cooperate and provide information in ongoing investigations and potential prosecutions of individuals, current or former employees. By then, they're almost always former employees. So these global arrangements that used to be the ultimate goal of lawyers like me are harder and harder to get, and that's an explicit term of the Yates memo. There's also more scrutiny on management responses to these large accidents. Prosecutors are going to be asking, did executives respond promptly and affirmatively? Once the accident occurs, did the company independently ameliorate the problem, make future issues less likely? This has always been an area of focus for the government, but with respect to evaluating exposure of culpable individuals, management response to accidents is going to be a central consideration. And again, the only way to prepare for that is to have a robust compliance program. That is the best defense. The argument to the government, you want the argument to be, hey, this accident was an aberration. Our response, our fulsome response, demonstrates effective culture of compliance here, and we have done everything possible in the wake of this accident to make it right. It actually is an opportunity for you to demonstrate that culture of compliance. Some of the ways in which the memo has been criticized, people predicted that the sky would fall with respect to cooperation. Nobody's going to cooperate now that it's required that you give up culpable employees. That has not been my experience. That has not been the experience of the department. It continues to be crucial for lawyers representing companies to do all they can to provide information to government agencies to preserve the interests of the company. There's also a concern that individuals are going to litigate cases more frequently, and that might make the case law, Clean Air Act, Clean Water Act, for your purposes, maybe fleshed out more, because while companies don't try these cases often, individuals will. Haven't yet seen much of that and don't know if that will come true. I'm not even sure that's a criticism. Maybe that would actually be a good thing, because it would provide guidance to folks down the road. And then there's been criticism that, hey, unless you're willing to offer scalps or unless you're willing to create scapegoats, then you're not going to get cooperation credit. We don't want to do that, and we're therefore not going to cooperate. Again, not quite sure that will be borne out. I wanted to highlight a potential conflict in the Yates memo and the DOJ policy with respect to privilege waivers. As most of you know, the department precludes a prosecutor conditioning cooperation credit on the company waiving privilege. That has been enshrined now for some years. But when the Yates memo is requiring the disclosure of information about culpable individuals, arguably there's a tension. The fact that you are disclosing may have been gained through a privileged investigation that, of course, is being waived to provide the information. Or, in a lot of these cases, you get into an issue of did this employee rely on the advice of counsel in giving a green light to something or doing or failing to do something. The Deputy Attorney General herself strongly disagrees that the privilege is in any way in conflict with the terms of her memo. We issued a client alert right after the Yates memo was put forth last fall, and it indicated that we thought there was this tension. And I got an angry phone call from Sally Yates herself at about 7 o'clock on that Friday night saying, I saw your client alert and I just disagree that there's any conflict with the privilege. We just want the facts. We just want the facts, not the legal conclusion. She's right when she points out that tension is present in every corporate investigation. There's always a sort of a dance about how much to disclose that may be privileged. But as she has said, they'll respect the privilege, but they will also expect companies to respect its boundaries and not wrongly exploit its legitimate purpose by using it to shield non-privileged information from investigators. The Yates memo applies technically only to the Department of Justice and its components, but we have seen other agencies now also focusing increasingly on individuals and companies who are being investigated by other agencies are being affected by the Yates memo. I recently represented a couple of employees at the Herbalife company in California. They're being investigated by the FTC. Nothing to do with the Yates memo, yet we're very mindful of the potential exposure and the need for outside counsel for individual executives. So while this memo applies only to DOJ, we are seeing a much broader application. My prediction, to read tea leaves going forward, I do think you'll see some individuals charged in big cases. I think Volkswagen, which I believe was sort of announced right around the same time as the Yates memo, is the first big one where you'll see, well, I think you've already seen just last week someone plead guilty, a Volkswagen engineer in that case. But I don't think you're going to see a substantial overall increase in cases against individuals. That's because the department, of course, was in the past evaluating charges against individuals. This isn't a new thing. And those are cases that are hard to make. The department's looking for evidence of intentional conduct or bad faith. They have not charged anyone under the PARC liability, the responsible corporate officer strict liability theory, even though the Supreme Court has blessed that, in years. So they're always looking for intentional conduct or bad faith, and that doesn't always exist. Sometimes when it does exist, it is so far down the chain within a company that there's a decision made not to reach that low within the organization in charge. So I don't expect a huge increase in actual cases and resolutions against individuals. In the environmental area, of course, there have already been a number of big cases where individuals were charged. The financial sector, where there's a little bit more trepidation here, but you all are used to working in your industry's individual exposure because it's happened before. There's been evidence in prior cases of intentional bad conduct, of failure to adhere to safety regulations, and as Shannon said, the prosecutor's best friend, false statements and obstruction. But regardless of reality, perception is what matters here. The memo itself and the attention it's gotten is going to make it potentially more difficult for companies to gather these facts, to do internal investigations, and all of this, just bottom line, makes robust compliance and response plans more important than ever. And then I know we're about out of time. I just added a few slides which just demonstrate, some of these go pre-Yates, that people do get charged. They get charged for everything from Clean Water Act violations to common law offenses like negligent homicide. Almost always see some sort of obstruction and false statements charge. These cases have been routinely brought and resolved unfavorably against employees, so there really is teeth to the threat. BP, Massey Energy, the Atlantic States case, and the Tonawanda Coke case are all examples of that, and easily those, if anyone wants more information about any of those cases, let me know.
Hey Tim, that was great. Thank you very much. We're about out of time. I want to thank everyone for, we've gotten a bunch of questions. We'll get back to people. I think I may ask Shannon one on release reporting here before we break. But before we break, I just also want to say we'll be circulating a recording of today, a PDF of the slides. So Tim's case studies will be in your hand. And then, please complete the attorney affirmation form if you want to get CLE credit for today's presentation, and include the CLE code word enforce 518. We did one question I think, Shannon, you could speak to because it actually came in twice, regarding release reporting issues that you see after an incident. That's something that is kind of an immediate response folks need to tackle.
Right. I'll be very quick, and then I actually want to ask Tim one question too. But I will say on the release reporting thing, that is very tricky for in-house folks because there are immediate phone calls that are required. And what Tom was saying earlier about training, having those scripts so that they don't say any more than they need to say in that phone call, recognize that the purpose of that phone call is to make sure that external responders can address the situation. That's the point of that. And so sometimes you don't actually know what was released. You don't know how much. And we're going to have to make reports the next day, that day, in a week, in 30 days, in 6 months, and a year under various statutes, Clean Air, Clean Water, EPRA, all of these. And so you want to be sure that you maximize the amount of consistency that you have, and that you do have caveats on the immediate reports that you submit, because chances are the numbers are going to change. And so you're trying to protect yourself against a claim of false statements and that type of thing. And so having prepackaged caveats is something that I always like to have when I was in-house counsel dealing with releases at various GE businesses. I would use that, and I just had a handy thing that, here's my script for the NRC, and I would send it to the person at the plant, because having it handy wasn't necessarily going to be the case. But if I had it and I got the call, I could get it to them quickly. And Tim, you mentioned about Upjohn. I was just wondering if you could please talk about what the core elements are of Upjohn and what in-house counsel need to think about in terms of how they give Upjohn warnings and know that they've gotten it in a post-Yates world.
Sure, Shannon. Yeah, I mean, the Upjohn warnings, everyone does it a little bit differently. My standard is to make sure that anyone we are interviewing, and again, I'm in the role of company counsel, is aware that my client is the company. You don't want to mislead an employee into thinking that you represent him or her. With that comes the fact that the company holds the privilege and may disclose these facts to outside third parties like investigators at the discretion of the company. Usually, Shannon, that is met with this is pro forma, it doesn't raise any concerns. Sometimes we have found more recently that the Yates memo and the sort of attention it's gotten makes people ask questions. Hey, do I need a lawyer? Do I need to be worried myself? It is, of course, the provision of legal advice to answer that question, and the company counsel or outside counsel for the company cannot do that ethically, give someone advice as to whether he or she does need a lawyer. One thing that you can do is provide a little bit more context as to, hey, we're trying to get to the bottom of this. The company wants to do the right thing. We're just trying to figure out what occurred here. Some general statements about the motivation for the investigation and the company's desire to do what's right sometimes can be helpful. I just think it's important for people to not neglect the Upjohn warnings, just be aware that they might raise some concerns that they didn't previously because of the attention that the Yates memo has gotten.
Great. Thanks, Tim. Thanks, Shannon, for that. And I want to thank everybody. I want to thank the other speakers today, Susan Wiltsey and Tom Bohr, and really delighted that we were able to spend the last 90 minutes with you all and that you have made time for it. If you have any questions, reach out to any one of us. The bios are in the back of the deck you're going to get, and I think you all are capable of tracking us down. Thank you again for joining us today.